Hi, I'm Matt Collins. I'd like to welcome you to Bob Weber Auto Mart on Douglas Avenue here in Racine, across from Douglas Park. We specialize in 1-year-old, low mileage, almost new cars. And if you'd like to stop by and see them, or see them on our website, bobweberautomart.com, we could save you between $5,000 and $10,000 on your next almost new car purchase.
I'm Michael Burke, and this is Money Talks. Hi, welcome to Money Talks, the Journal Times online business show. I'm business reporter Michael Burke, and today we're going to be talking about legislation, federal legislation, with Peggy Kelsey, corporate counsel at Modine Manufacturing, and Jessie Lochmann of Foley Lardner. And this piece of legislation we're going to be talking about has everything to do with conflict minerals, which I'll let you introduce in a second, Jessie. But it comes out of the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010. That's a mouthful. But in that act was, I think it's fair to say, it was little known at the time, correct? This conflict minerals legislation?
I think that's very fair to say, yes.
Yeah.
Bit of a surprise.
Yeah. So why don't you take it from here? Conflict minerals, because there's this strange connection now under U.S. law between, of all things, the Congo in Africa and U.S. publicly traded companies that we'll be getting into. So what are conflict minerals, Jessie?
So conflict minerals, in connection with this new SEC rule that Congress has required SEC to enact, are a few specific minerals: tin, tantalum, tungsten, and gold. Minerals that you may not have thought about prior to this particular rule becoming effective, other than they existed in your supply chain, but now they're very important because all SEC reporting companies, so all companies that have a class of securities that are subject to the SEC rules, must report by May 2014 on the existence of those particular minerals within their supply chain and their products, if those minerals were sourced from the Democratic Republic of Congo and countries that had joined that in Africa.
Which most companies would not know necessarily.
Which most companies would not have otherwise known, number one, whether or not those products existed in all the components within their products, but in particular would likely not have known whether or not those minerals were sourced from the Democratic Republic of Congo or various countries. I mean, it's a pretty specific fact that companies somewhere in their supply chain may have known, but certainly wouldn't have had the reason to understand and summarize for all of their various products.
And let's explain the reason for this. The ostensible reason for trying to find that out is because of the warring and the exploitation that's going on. You want to explain that a little bit more?
Sure. So as you mentioned, Mick, this requirement that the SEC enact rules here ended up in the Dodd-Frank Act. The Dodd-Frank Act generally related to Wall Street issues, but this humanitarian-related topic made its way into the Dodd-Frank Act as really a miscellaneous provision. But the goal, from Congress's perspective, was to provide some humanitarian relief to conflict in this very war-torn, strife-ridden area, because the concept is that the mining, the extraction of these various minerals oftentimes fund the conflict and the bad guy, so to speak, in that particular area. So although I think we should make clear, nothing in this rule, from Congress's perspective or SEC's perspective, makes it illegal to mine or to buy or to utilize these various minerals from the Democratic Republic of Congo. What the rule says is that you need to disclose to the public through your SEC filings if you do in fact use those minerals. And the idea from the Congress perspective is that the identification, the public shaming of this issue may result in companies deciding to only use conflict-free minerals in their products.
So if Modine finds out that it's got tungsten, and that tungsten comes from the Congo or any one of the 9 adjoining countries, somewhere there's going to be a report that says Modine's using tungsten from there, and that's a bad thing. And then Modine goes and says, okay, we better find another source. So that's the whole
idea.
theory. That's the whole.
That's the idea.
Yeah, and of course, which has. How much does this have to do with cleaning up Wall Street, Jessie?
Oh, I think absolutely zero. I mean, this is definitely not intended.
This
to
is one of those things that gets stuck onto a bill, maybe to gain somebody's vote for the bigger bill or something like that. It's the ride along. It's the stowaway in the bill. So that's the reason for this bill. Before I ask Peggy to talk about what Modine is doing, what do you think is the general state of now? You mentioned the first reporting deadline it's the end of May of 2014.
Yes.
We're doing this show on July 2nd of 2013, so we're less than a year out. What do you think is the general state of thinking among publicly traded companies such as Modine, Twin Disc, Emerson, which owns InSyncrator, companies like that we have here that are publicly traded?
Sure, and so to clarify, the disclosure needs to be made by next May. The reporting period is calendar year 2013.
Mm-hmm.
So companies need to report about what was included in the products manufactured during calendar year 13. So we are in the middle of that year, and I think for companies like Modine, and Peggy can certainly talk to us more about this, companies need to be and should have been already very involved in their processes with respect to the identification of the various components that go into their products, and then questioning and investigation of their supply chain. Because, and we will, I'm sure, get to this, it is important to note, and I think at the outset it's very important for us to make clear that while this is a rule that is applicable to public companies, so public companies like Modine or Twin Disc, as you mentioned, it is impactful in a very serious way on the private companies that supply to the public companies.
Yeah. And let's explore that some more. Peggy, when did Modine start working on this, and what have you learned about how large a task this is so far?
So we started paying attention to it when the fact that this was in the Dodd-Frank law became public knowledge. So we were obviously focused on other aspects of Dodd-Frank. When we became aware of this, we started paying attention. But
Can I just jump in and mention
Sure.
the law was passed in 2010, but
That's right.
these rules don't appear overnight.
Right.
When did these rules that you have to follow come out? And I think you've actually brought something to sort of illustrate.
Yeah, so I'll show you. This is the law. So this is what came out in 2010. This is part of Dodd-Frank, so pretty small. In August of 2012, this is the rule. This is double-sided. This is the rule.
That's double-sided, and it's a
the
good
SEC
inch thick or more.
So what the SEC has to do in its defense is when Congress tells the SEC, promulgate a rule, pass a rule, the SEC needs to do that. And the SEC goes through a process of rulemaking in order to do that. So it solicited public opinion. It came out with a proposed rule and got an onslaught of opinion from companies, from various groups. Then it came out with its final rule. Well, once the final rule came out in August of 2012, then we all had a roadmap of what it is we needed to do. We were already looking at the proposed rule because we were getting a sense of what we were going to have to do. Once August of 2012 hit, though, then we knew exactly what we had to do, and from that moment on, started preparing and actually doing work so that we could comply by May of 2014.
So you've been at it for a little less than a year now, maybe 10 months or something like that. What have you found out so far about how you go about tracking these back through your... How many suppliers does Modine have? How many different things do you manufacture? Yeah.
Oh, well, way more than we're looking at. I could tell you, we've gone through an analysis. I'll just quickly run through how did we peel this onion back, as you and I talked about this a couple of weeks ago. So we started by talking to the materials specialists within Modine. We're a manufacturing company. We have a lot of people who are specialists in designing things, manufacturing things, and then what materials we use. So started by talking to those people and said, now where do you think these three TGs, tin, tantalum, tungsten, gold, could be in Modine's product? So what makes sense here? Started narrowing it down from there. Then we said, all right, what material specifications fall under that sort of risk analysis? Then we said, all right, what products does Modine make that use those material specifications? And for every one of those products, which is well over 20,000, we said, what 20,000 parts we have to look at, looked at every bill of material and said exactly where is this stuff used.
Do you want to explain a bill of material?
So a bill of material is kind of like the recipe for producing a product. It says exactly what we're using and in what quantities. And so, but it's not so easy because a bill of material may call out a specific grade of metal, for example, and it may tolerate a trace amount of tin, but it doesn't require tin. But we're telling the manufacturer of that particular, steel, for example, will tolerate contaminant tin, for example. Well, that is not covered by this rule. It's not necessary to the functionality or production of the material. It just happens to be there. But if we call out a specific grade of steel that needs tin in it, or solder that needs tin in it, well, that's covered. So we had to go through that whole analysis and then identify, well, which suppliers across the globe, this is not just in the U.S., across the globe, what suppliers do we have that are providing those materials to us? Sometimes they're raw materials, sometimes they're purchased parts. So, for example, if we're buying motors or wire harnesses or those types of things, we have to look at those. But we also buy steel in its native state, and we have to look at that as well. So it's an enormous undertaking.
Wow, 20,000 parts.
So yeah, going back to your original question, I think Peggy outlined very well what companies are doing, which is number one, identifying, are you as a company a manufacturer of a product where one of these particular minerals is necessary to the functionality or manufacture of that product. Next step being somehow internally identifying how companies are going to do their reasonable inquiry with respect to the various suppliers and the parts. And after that happens, which oftentimes is not as organized as what Peggy's company is going through right now, because it's just new and you need to identify the people within the organization who have the information and the understanding and the time to do this. Companies are buying software to help them sift through this. I mean, it's a huge endeavor just to get to the point, I think, where you are. And then after that, it's questions. It's questions of the suppliers. A lot of companies are now at the point where they're issuing specific questionnaires to all their various suppliers, and we're helping with those questionnaires to ensure that the questionnaires are eliciting the information that the companies need to decide if they then need to move to step 3, which is to do additional due diligence on the suppliers and the source of the minerals.
How many suppliers does Modine have, and what's the range and the number of suppliers that a public company may have?
So we have many more suppliers than are involved in this, but the number of suppliers we have that we're going to need to tap into is over 1,500. These are direct material suppliers who are providing things to us that right now we believe contain 3TGs. Now, we haven't even gotten to asking the question, where did they come from? So that's separate. So as Jessie said, Mick, we're just on the verge of issuing requirements to our suppliers that they fill out these questionnaires. And we have signed up for a system, it's called iPoint, that came out of the automotive space, that is sort of an online service that you can require your suppliers to use to answer your questions so that we can keep track. So we've started in the United States with our North American operations. We're about 90% complete there, although we just had an interesting new thing pop up, which is that some epoxy paint has tin in it.
Is that right?
So we've said, all right, we thought we were near 100% done with the identification in North America. Now we're taking a step back and saying, all right, now we need to know where we're using epoxy paint and then what suppliers are supplying us so that we can figure that out. So let's make it a little bit.
So you're 90% complete with the process of identifying products that may have 3TG. That do have.
Yes.
But you're certainly not 90% of the way to knowing where those 3TG come from, correct?
We're almost 0% of the way to knowing where they've come from. We, many months ago, put all of our supply base, the suppliers we knew were going to be involved right away, we put them on notice and said, hey, this rule is out there, we have to comply. Now again, as Jessie said, they don't. There's no law requiring them to comply, but we have told them in no uncertain terms, part of the cost of doing business with Modine is you have to assist us here. So, and we have a notice out, it's sitting on our website that says, Modine wants to use conflict-free minerals. We definitely do, and we've told our suppliers, we expect you to make that happen. Well, you can imagine you may be looking at a mom-and-pop supplier on the one hand, or a very large steel manufacturer, but either way, they may have 6 or 8 or 10 sub-suppliers below them, between them and the mine,
Right.
trying to figure out where did this stuff come from.
Right.
So
especially
it's
if somebody
quite
makes a
complicated.
motor or something that goes into
Right.
a Modine product, a motor would have many, many parts.
Exactly.
And those parts would come from many different, as you say,
Yes.
maybe just some little job shop someplace or something like that.
Right, and it's not static. So, for example, we may change suppliers. One of our suppliers may change sub-suppliers midstream. So what was true today may not be true tomorrow. So that's why we put them on notice so early, that they needed to be paying attention to this, so that if they were switching, maybe they could try to go to a conflict-free. But right now, there's a program trying to identify conflict-free smelters, and they're starting to make some headway there, but almost not at all on tin, which is Modine's primary focus. So
Because it's in solder?
because it's in solder, and it's in both stainless and non-stainless steel that we use in quite a lot of our products. Our exposure is primarily tin, and maybe a little bit of gold. We're not sure if there's gold in some of the purchased electronic components that we buy. As I mentioned to you, we do not believe we have any exposure on the tantalum or the tungsten at this point. Something could crop up, but at this point we don't think we do.
What within a company like Modine, you could speak to this, or you could speak to this, what departments tend to be, I know you being in legal, you're at the very center of this, or the forefront, however you want to look at that, but what other departments are being pulled in and people's time being sucked up by this?
The primary leader within Modine is our Vice President of Global Purchasing. His name is Brian Lee. Brian is spending an inordinate amount of time on conflict minerals because Brian controls the supply base across the globe. So he has people working for him across the globe who are literally purchasing all this stuff from Modine. So while I can sit in legal and tell them what we need to do, look at what they're doing and say whether it makes sense, they're the ones doing all the nitty-gritty. Now, attached to them are the engineers, the material supply folks, the material specialists, the folks who control our bills of materials. And again, this is across the globe. So right now we're hitting the North American business unit hard, so our vehicular unit out of North America. Then we will start moving on. We think we know where our biggest risks are across the globe. We think it's Brazil and Hungary, based on the products they produce for us. Because it depends on the nature of the product produced, whether we think there is a risk of exposure for Modine. So we are probably going to start shifting to the facilities in Hungary, the facility in Brazil after we're finished with North America. So what we've done here, Brian is going to replicate around the rest of the globe. And the real trick then is trying to create it such that when we get to the following year, because the idea is this is an annual disclosure and you have to redisclose. As I mentioned to you, you may switch suppliers, your supplier may switch suppliers. How do you make sure you can continue to provide some reasonable disclosure every year? It's pretty complicated.
Well, the SEC itself quantified or estimated the cost of compliance. Do you want to mention those figures? Do you know that?
So the SEC in its adopting release, so the first cut at the rules started with a very low number, an estimate that was in the hundreds of thousands of dollars per company, with extrapolation for the 6,000-ish public reporting companies. In the adopting rules, so moving from proposing to adopting, in the adopting rules, the SEC said that it thought the cost of compliance would be worldwide about $3 to $4 billion in connection with the reporting companies. What's interesting about those numbers, though, is they really don't take into account the private companies that are being impacted by this. The SEC's rules are quantifying the impact that they expect to have on their reporting companies. And so clearly Modine is going through a lot of time, cost, energy. Some of it's probably not quantifiable, right? It's the diversion of management attention or otherwise. You asked what other companies are doing. I think they're replicating what Modine's doing in some way, shape, or form, but certainly it's audit, procurement, legal, and then really it's rising to the governance level as well. I mean, C-suite executives are worrying about this because they're worrying about not only the disclosure, but the impact from the public perception and public scrutiny, which is really, I think, what the Congress and SEC were going for here. How does that impact otherwise their business decisions? Are companies going to adopt we're conflict-free or would like to be conflict-free policy or not? That's a governance decision that you made, I'm sure, at the highest levels, that we want to disclose to the world that this is how we're going to procure our products or our supplies and components. Not all companies are making those decisions, but again, there could be governance implications for not making those same claims.
Right, right. Let's touch briefly on the fact that there is a lawsuit, a federal lawsuit going on. You want to talk about that a little bit?
The U.S. Chamber of Commerce, the Business Roundtable, and the National Association of Manufacturers have sued the SEC for various reasons relating to the adoption of this rule. Actually, oral arguments were heard in the D.C. Circuit of Appeals just yesterday with respect to this particular lawsuit. I think when the lawsuit was filed earlier this year, there was hope by at least some public companies, certainly clients of ours, that this lawsuit would wipe out the rule, at least for a time being, right? That this would somehow cause a delay in the inevitable.
And so maybe they were dawdling a little bit on
I would say
compliance?
that, yes, there are certainly companies, and there are general reports that many companies at least waited through the first quarter and maybe some through the second quarter in the hopes that they would get to the point where that these rules would be stayed. Given where the lawsuit is, and again, the lawsuit is attacking the rules on a number of bases. One, with respect to whether or not the SEC took into consideration the way it should have the cost, the general economic cost. And another point that the business side, because it's really the business world that's attacking this, another side that they're attacking is whether or not the SEC provided enough exemptions and relief. There's no relief for trace amounts, for example, in products. I mean, it's any amount is covered and needs to be disclosed and needs to be identified and worked through. That's a discussion about whether or not the SEC took Congress's rules and adopted it in basically rule regulation, explicit detail form in the way that made the most sense for the authority that the SEC was given.
And where does it look like that lawsuit may end up? Any projection?
So if I were a betting woman, I suppose, I would say that I think it is unlikely that there will be relief based on the lawsuit. Again, it's very early to tell, as Peggy, we said offline, it's difficult to know based on oral arguments in the first day what the court or what the judge is thinking, but certainly it doesn't seem that companies should be waiting to comply based on the lawsuit alone.
Gotcha. Well, really interesting stuff, and not easy stuff certainly for our public companies that we have here, or any others. Jessie Lochmann from Foley Lardner, thanks a lot for being here. Peggy Kelsey from Modine Manufacturing, thanks for being on the show.
My pleasure.
Good luck with this, getting through this process.
Thank you.
You've been watching Money Talks. I'm business reporter Michael Burke. Thanks to our producer Greg Shaver, and please remember, Money Talks.